Section 363B of the Bankruptcy Code generally permits a debtor in possession to sell property of the debtor's estate outside of the ordinary course of business. In Re Chrysler LLC, the court considered whether a debtor in possession could sell substantially all of its assets to an entity that would operate as a similar business if the only alternative to the sale was a liquidation. Chrysler LLC, which we'll refer to as Old Chrysler, was an automotive manufacturer. For several months, Old Chrysler experienced significant losses. Old Chrysler made several attempts to save its failing business, which included receiving federal bailout funds, searching for a merger partner, and seeking funds to restructure. When these attempts failed, Old Chrysler finally decided on a bankruptcy plan that included an asset sale pursuant to Section 363B. Under the plan, Old Chrysler would sell its operating assets to a new company, which we'll refer to as New Chrysler. In exchange, New Chrysler would pay $2 billion in cash and assume Old Chrysler's liabilities. Fiat S P A, another automotive manufacturer, would provide New Chrysler with resources in exchange for a 20% ownership interest. The United States and Canadian governments would provide additional funding in exchange for a 10% ownership interest in New Chrysler. An employee benefit entity created by an auto workers' union would also receive a 55% ownership interest in New Chrysler. The asset sale was the only viable option for Old Chrysler. The only other alternative was a liquidation, which would have yielded over $1 billion less than the proposed asset sale. In 2009, Old Chrysler filed its prepackaged Chapter 11 bankruptcy petition. The bankruptcy court approved the asset sale. Certain secured lenders and tort claimants, whom we'll refer to collectively as the objectors, appealed the approval. The objectors argued, in part, that the sale was essentially a disguised or sub rosa reorganization plan and that it was therefore impermissible under Section 363B. The Second Circuit affirmed the bankruptcy court's order but stayed its full decision pending Supreme Court review. The Supreme Court declined further review, and the Second Circuit considered the arguments in full.